Hear. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston within the Commonwealth. Draw near, give your attendance, and you shall be heard. Now sit the Commonwealth of Massachusetts, court is open, please be seated.
Good morning. Welcome to the Appeals Court. I am Justice Rubin, and to my right, Justice Singh, my left, Justice Hershfang, wait, right, left, okay. I did that right. We owe you a huge apology. We know you've been waiting. We had our first argument today by Zoom, and there were technical problems that I gather someone has let you know, but we really apologize for the lateness of our getting to the next argument. We will hear the next argument, though. It is, I should also say, as you may well know, our rules are straightforward. It's 15 minutes per side, and there is no rebuttal. And in those cases where parties may be dividing their time, they have to alert us before the argument begins of what the division is. So, with that, I will call our first case, number 23-103, Commonwealth versus Jiminez. And we will hear from Attorney Hill.
Good morning, Your Honors. Kathleen Hill for the defendant, Hector Jiminez. May it please the Court. This case is a case in which it's the position of the defendant that the trial judge erred in denying the motions for directed verdict because the evidence is insufficient to have found Mr. Jiminez was the robber. On the first piece of evidence that we look at, that we know, is from the victim herself. Ms. Irani states that the person that robbed her at the Bank of America ATM was 5'8". He was white. He had light eyes. And Mr. Jiminez is the total opposite. He has dark hair. He's 5'4", and he has brown eyes.
The jury had video of the robbery taking place.
Yes, Your Honor. I think if you look at the video is, just as the prosecutor stated, the most crucial evidence that was put forward to the jury. The quality of the videos in 2015 was of a poor quality. Some were of poor quality, some were of higher quality. The ones inside the ATM are of higher quality, and at the very beginning of the first, I don't know if it's the first, of the video where the robber appears on the bike, you can see quite clearly his blue and black checked pants. Yes, you can.
But go on, yes.
Yes, you can, Your Honor. You're correct. I do believe that the ATM video at Bank of America is the most clear. However, at no point in time are the facial features recognized because the individual is standing too far back from the actual ATM. When you see Ms. Rani, you can see her features, her skin tone, her hair color, and you can see from the robber, you can see the robber's hands, and you can see that the individual is clearly white. And in fact, Ms. Rani is so certain that
maybe clearly white, light-skinned. I don't think we can tell what the race of that person is necessarily.
I think Ms. Rani herself also on her 911 call moments after, she tells the operator that it was definitely not a dark-haired individual because she also saw features on the hands of the individual. She had 3 opportunities to observe this individual when she turned around and she first was approached by the robber who entered the ATM, which that door was unlocked.
3 opportunities in quick succession while she's being assaulted.
Yes, it is quick opportunities, however, it does extend over 2 minutes. The robber knocks out the cell phone from her hand and it falls on the floor. He picks it up and she has specific contact with him. We can see in the video that she's making this motion before him, pleading to return her phone. They're talking. There's an exchange of communication. There's also an exchange of communication between the robber and Ms. Israni when he does, in fact, return the telephone to her. So she knows certainly it's the closest in time.
But again, you know, in terms of the required finding argument, there was other evidence, right? The jury could have rejected her account. They had a video themselves to look at, to judge. They had videos themselves.
To identify the suspect?
To evaluate her ability to make those descriptions that she did. For example, they could see that she probably didn't get a good look at the head on his hair to be able to describe him as she did. So they could choose to maybe reject her description and rely on other evidence to come to the same conclusion of identification.
I don't think to make identification, I don't think you can rely on the quality of video that you're looking at, particularly when you compare it to...
It was circumstantial, it was all the circumstances.
But Your Honor, I respectfully would state Commonwealth versus Davis, I think best supports the case. Commonwealth versus Davis is 487 Mass 448. It's a 2021 case in which this court rejected that due to the quality, you can't identify an individual, the suspect in this instance.
Identity was made through other things, through clothing, through the bicycle, through the timing, right? I mean, it sounds like your argument is going to the identification of that individual at that time without regard to all of the other factors.
Yes, when you look at the timing, that is critical, and that was the main point of our argument, is that the alleged suspect that supposedly went to the Old English Village by 7/12 at that time. You look at the date stamp, and on that time, the arrival of that image, which also was poor quality, you couldn't make out any facial features. That was 10:35. The robbery took place between 10:57 and 10:58.
You can line up when the police cars arrive and see that there's something wrong with some of the timestamps.
The only timestamps, Your Honor, that you can see is that there appears to be a problem are the videos that are out at Stairway Plaza. Those videos there of poor quality, those timestamps suggest that it was 10:35, but we know it's not because we have the CAD report. We have the quality of Bank America video that had a timestamp that's accurate and gives us a better depiction of what happened, as well as we have the manager from OEV, Mr. Simon, that has told us and testified the timestamps are accurate. You can also pair the videos yourself with the timing. You can see the police cars coming into OEV as they're checking for surveillance between roughly about 11:03, 11:04, all the way to 11:17. That time's up with the CAD report. So there's a problem with those stairway videos, and that's the whole point. In fact, there's a video that was 36 seconds long that was produced. And that 36-second video only captured Ms. Israni going out and returning in after the robbery. And the Commonwealth's argument is, well, it's motion detector at this commercial building. Well, where's the video when she arrives, when she first arrives? Where's the video of the robber leaving on his bicycle?
But these all sound to me like great trial arguments and great cross-examination questions. The question I have is why, I mean, I understand you are contesting or you're contending that the denial of the motion for a new trial was inappropriate, but aren't you asking us to engage in weighing the evidence and to weigh it differently from the trial judge?
Yes, I think you should, because when you look at all the evidence, the focus was not, although the argument the prosecutor says in closing, the focus is on the videos, it's really the trial attorney's trying to show it's on the other evidence. It's on the DNA. It's on the fingerprints of the bike. It's the fact that this bike, Mr. Jimenez wasn't arrested until 3 days later. Take by comparison of the cases that the Commonwealth relies on when they say there's a mosaic of evidence when you put this together, and they're citing Commonwealth versus Linden and Commonwealth versus Brennan. And these cases in Commonwealth versus Jones, these cases show you there's one step needed more. In all three of those cases, there's the individual that immediately after the incident was picked up and detained within moments by the police. And in addition, there was also inference of guilt, the path they took on.
So when an unknown robber gets away, there's insufficient evidence to convict them?
No, there's not, because you have identity as well, too. And don't forget that...
I said an unknown robber.
Unknown at that point in time, but the individual could have been identified.
They're not. Okay,
and then trial.
I mean, this sounds like a fine Bowden defense, right? Which was made. I just, the idea that it's insufficient. Now, I agree. If you had irrefutable proof that the person in the video, because of, for example, skin color or something, literally couldn't be the defendant, then maybe you'd have something. But none of this is irrefutable. I mean, I looked at the, obviously not obviously, but I've never seen the defendant, but I looked at the picture from the driver's license, and I looked at a lot at the video, and it is not clear to me that this could not be the same person. And she said he had blue eyes. I mean, I look at the video, I know it's imperfect, but that's just not how that looks to me. Eyewitnesses are notoriously bad. You know what I mean? People get their convictions reversed because of the poor quality of eyewitness testimony. And I understand there's no DNA here. There doesn't have to be, although it's a pretty good argument to a jury, it seems to me.
Yes, and there was no DNA evidence. With the DNA evidence, the DNA was taken from a bicycle. The reports were submitted of another robbery in which that individual was unknown, and it was those test results that came back with no fingerprints. However, if you look at those reports as well, too, you'll notice that there was skin cells, and that could have been tested, and that wasn't tested.
Well, the clothing presumably could have been tested.
Yes, the clothing could have been tested too, and that's another issue, a problem that as we move on with the arguments, and that's where Detective Coughlin stated that she didn't need to test the DNA because she knew who was wearing them.
Yes, but that was used quite strongly in closing, right? I mean, that's such a dumb thing for a witness to say, right?
Yeah,
I understand that you're saying it's a rush to judgment, but that's your defense. Your defense is this, look at this. She says to you she knows who it is without testing.
Yes.
What is that?
Yes, it's your defense, but it's also reversible grounds. It's an improper opinion of guilt, and that should not have been gone forward to the jury, particularly with such weak evidence where you're going to have to draw the inferences by circumstantial evidence. And
I mean, you say it's weak evidence, and I take your point as echoed by Judge Rubin about the frailty of eyewitness ID testimony. We all know now that's not the gold standard we thought it was 15, 20 years ago. But how about the clothing? I mean, couldn't the jury look at the video in the ATM, look at the clothes that were found under the bed in the apartment that your client's mother rented or owned, I don't remember, and put those pieces together and conclude your client was the robber?
there were also 5 individuals that used that apartment. And as you recall, David English had the keys to the apartment. Mr. Jimenez did not have the keys to the apartment. When he was arrested, and he didn't have the keys. He didn't have any keys on him as well, too.
Is there not evidence, obviously refuted evidence, but evidence from a police officer that the mother said that's Hector's stuff or something like that?
No, there's not. Not for
So-
purposes of the trial, Your Honor.
Oh,
There's not.
that was in the motion to suppress.
Yeah, yeah.
It was not brought out at trial.
It was not brought up, it was not allowed at
Interesting.
the trial, so
Okay.
you don't have that tied. But the Commonwealth could have also called David English, and he was there, he was present at that time, if they wanted to link the clothes to this individual. But the mother specifically testified that they were not Mr. Jimenez's clothes.
Was there any evidence that David English used the bicycle?
I'm sorry, Your Honor?
Was there any evidence about whether David English used the bicycle?
There's no evidence who used the bicycle, whether it was any individual at that apartment complex or if it belonged to the public housing next door that was also connected. No, it could have been tested further, but the Commonwealth didn't request any further analysis on the test, so you don't have any DNA evidence. And this is exactly the
Oh,
point.
but there's evidence that the defendant was riding the bike.
I don't think so, Your Honor. If you take a look at it carefully, nobody actually saw him riding the bike.
I
The
thought
arresting
Officer
officers.
Coughlin thought it was him.
And then he
Didn't
said,
she
"I
give
saw
a
you."
description or something to the officers who stopped?
Him
and this other person?
No, it was when the officers approached, the bicycle was already against the wall. There was no, it was just a general description of a jacket and jeans, and the arresting officers did not see who was riding the bicycle.
Were both of them wearing jackets and jeans?
Well, they also, in the police report with regards to the second individual that was standing next to the bicycle, and Mr. Jimenez was next to his car, they didn't put any of that in the report. They just talked to the individual, who was also of Hispanic descent, and let him go away. So there was never any investigation as to who was riding the bike by the actual individuals there, as well as the woman that was in the house.
All right.
So-
Your time has expired, though. Okay, thank you very much. Excellent argument.
Thank you so much.
We will hear next from, I get these lists, I can't, from Attorney Ferreter.
Good morning. If it may please the court, Timothy Ferreter, Assistant District Attorney for Middlesex on behalf of the Commonwealth. I would be remiss if I didn't address the last issue in the defendant's brief, which is the allegation that the Commonwealth edited out exculpatory evidence from a file that we supposedly didn't turn over. There's simply no evidence of this. All of the 724 Chelmsford Street video appear to be motion activated, and they constantly have timestamps that skip ahead, suggesting that they're motion activated. And the defendant's reason for why we would have needed to edit out exculpatory evidence just doesn't make sense. There's a video from Old English Village that shows the entire driveway, and it shows the bike going up the driveway. It never shows a man going down the driveway after the robbery on a bike. So this supposedly need to get rid of exculpatory evidence just doesn't exist. But there's a whole nother video that shows the whole driveway.
Is the statement, "I saw you," by the defendant the only evidence there is that it was he and not this companion who was on the bike?
Well, he was also standing next to the bike when he was arrested.
Yes, so was the other person.
Right, and then the statement, "I saw you," yes,
I
correct.
understand. So I'm asking if that statement, "I saw you," is essential to proving that he was the person on the bike.
I think it's part of it. I don't think it's essential. but
Okay,
yes,
what
it's
else?
part.
Well, I say that because we're going to get to the Miranda question in a second.
Sure. So the Detective Coughlin gave the description, and then that person was, and then followed him, yes. So I think there was. that part
Wait,
of
the
it.
description was
The description was a man in a gray sweatshirt.
in a gray sweatshirt
The other
on the
person wasn't
bike.
described. That is correct.
And is there any evidence that the other fellow was not in a gray sweatshirt?
There's no description of the other person, no. So the "I saw you" is an important.
So the "I saw you" you think is critical
Yes.
to him being on the bike? All right. Now, I don't know if we can or should address this in the first instance. My general inclination is no. But why isn't it a Miranda violation?
There's just no record for this court to review in this case, is the biggest issue. There was never a motion to suppress based on Miranda. The motion was based on relevancy, so there's just simply no.
So you're
relevance.
saying that although there's evidence of her saying to him something like, what's going on? She calls him by Rocco. I don't know if that's because that's his nickname or she calls people that. But what's going on, Rocco? And he says, I saw you, implying that they looked at each other and it was indeed him on the bike who looked at her. And you're saying, even though the evidence at trial might make it seem like, well, he's in custody and she did ask him a question.
Well, then you also have the issue of whether it's interrogation. I don't think saying hello to someone is interrogation.
Well, it's a question, and under Rhode Island v. Innis, a question is interrogation, but all right.
Well, you also have the issue that there's no record, there's no ruling below, there's not even a motion below, so there's nothing for this court to decide on. So there's really nothing for this court to rule on where the motion wasn't made. So I think you're left in a situation where if he wants to bring a motion for a new trial based on ineffective assistance for not developing that argument below, he can do so, but there's nothing for this court to review in terms of Miranda warnings.
Okay.
As to the sufficiency argument, here the evidence was circumstantial, but it was sufficient to narrow the universe of people down to this defendant. And as this court has pointed out, there's conflicting evidence as to the description of the suspect, whether he had light eyes as the victim testified to, or they could look at the video, which is at chest height from the ATM machine, where you can see that he has dark eyes, and it's for the province of the jury to make that factual determination. And then the other evidence to close the flight path all lead back to this, to the defendant as being the robber. And I know there are a few other issues, and I'd be happy to address them if the court has any questions. If not, I'll rest my brief. Thank you.
Thank you very much. Very good argument. Both of your briefs were excellent, so thank you. The case is submitted. The next matter before us is Commonwealth versus ZJ. This is number 23-96. I gather there remains, at least right now, some kind of impoundment order in place. So although there may be no need to use a name at all, we'll stick with initials. And we will hear first from Attorney Rossile.
Good morning, Your Honors, and may it please the Court, Luke Rossile for the appellant. The issue before the Court today is a pure question of law regarding the scope of the expungement statute, General Laws, Chapter 276, Section 100K. I want to start by trying to address why this case presents a pure issue of law, then move on to the demonstrable error and the fraud on the court prongs of the expungement statute. And this is ambitious, but if there is any time remaining, talk about the best interests of justice inquiry as well. And so starting with the reasons why this is a pure question of law, at the hearing on the motion for expungement below, the trial court explicitly stated that it was accepting everything ZJ was saying.
I disagree with that reading of the transcript. The court on page 5 of the, which is the last page of the hearing transcript, says, even if I accept everything that you're saying, which I do, you don't need to stand in for an expungement, etc. Is there any reason to believe that the court is addressing the client rather than the attorney at that point?
Certain, just that the attorney was representing the client and that the attorney...
But the client, well, that's very sensitive face reading. The client didn't speak. So how can, even if I accept everything that you're saying, be a reference to what the client, to the client's affidavit? I mean, I take it from your brief that you are arguing that that statement by the judge is an acceptance of the truth of the statements in your client's affidavit. Do I understand the argument correctly?
Correct.
Okay. Why?
And so I guess I would push back, Justice Hershfang, against the assertion that the client didn't speak. It's correct, there was no oral testimony. The client did speak through their affidavit. And to the extent there was any fact-finding done below, that brief statement by the trial court is the fact finding. There's nothing else that can be construed as a finding of fact by the trial court. If the court should have done more detailed fact finding to allow this court to understand whether or not the trial court was accepting the affidavit as true, perhaps that could be grounds for a remand to clarify that part of the record. Certainly if there was any fact-finding done at all by the trial court, which is necessary in order to dispose of an expungement motion, that is the fact-finding. The court couldn't have disposed of the expungement motion except by deciding which version of events the court was adopting as true.
Okay, but when you say which version of events, the question before us is whether, to the extent there's a legal question here, is whether, in fact, there is clear and convincing evidence that these records were created by demonstrable police error.
Or fraud on the court.
Or fraud on the court. That seems a little trickier here, but let's go with either of them, both of them. So the police show up, there's a circumstance, let's say it's debatable about who's doing what, why is he holding her arm, what's the deal with these keys, you know, whatever. And they decide, as police have to do lots of times in domestic violence situations, that he's the problem. Let's call it mistakenly, but that's what they conclude. There has to be demonstrable police error. He later comes in and brings in 2 videos that he's chosen from however many zillions of hours of videos there are that show that in fact, and I haven't seen these videos, but that in fact, she was the aggressor in 2 circumstances, or the perpetrator of domestic violence at least twice. Doesn't mean that he isn't also a perpetrator of domestic violence. And then you say, but there's recording equipment around. And so the police, before they can arrest someone for domestic violence, have to make inquiry on the spot, when you might want to separate these people, make inquiry about, is there video, what does it show, where would we look at it, what server is it on, can we get a copy of that, before we even remove this guy and arrest him based on our judgment that he's the aggressor. We have to do this possibly quite complex piece of investigation. And P.S., it's not as though your client has said, if they had done it, here's the video, and you can see that he wasn't the aggressor. We still don't know who the aggressor was that night. The mere fact that she was an aggressor twice doesn't mean she was the aggressor that night. So how can it be demonstrably erroneous? Yeah.
So certainly, Your Honor. So I would push back on the assertion that there was any complex investigation that had to take place here, or any inquiry of any kind, because the police report itself, Officer Callahan's report at pages 17 and 18 of the record appendix, state that Officer Callahan was aware on the scene of at least 2 potential recordings, 2 actual recordings. One is that the booking crew informed Callahan that ZJ's phone had been recording up until the booking processes. So
okay, so at booking, when they look at his phone, they see that he's recorded something.
And so perhaps that was after the fact, but at the scene, Your Honor, the alleged victim stated that most of their arguments are over the cameras and recording devices in the household.
Having an argument over a camera is different than a camera captured the events that I'm describing. She doesn't say that. She doesn't say there's cameras here recording everything. She says usually we fight about him wanting cameras here and me not, or whatever the fight was. Mm-hmm. Do you see what I mean? I'm just, to get to demonstrable error, it seems like you're imposing an affirmative duty on the police to do an awful lot more than they might, without committing any error, do in a fast-moving, violent situation where there's a need to protect at least one of these 2 people from the other.
And if there hadn't been the existence or potential existence of video recordings brought to the officer's attention at the time, I think I'd have a much more difficult argument, and it would be in line with what Your Honor is saying, Justice Rubin, that I'm arguing the police had to do extra investigation. But I think the demonstrable error argument is that when the police have reason to believe that there was recording equipment operating in the alleged crime scene, it's demonstrable error for them not to at least try to look at those recordings when there's a dispute about who the aggressor was.
People are arrested at gas stations for robbing them all the time. And the next day, some police investigator goes to the gas station and says, "Do you have security cameras?" And of course they all do. And they say, "We'd like to get a copy of the whatever digital files that you have." And you're saying you can't arrest someone at the scene of a robbery who says, "I didn't do anything." You have to, you know there's a camera there. You have to go in, and while you're holding the person in the police car or something, you have to ask for a copy of the video recording?
I think the way to reconcile that analogy with the facts of this case, Your Honor, would be that at the gas station, there was a fight between two people, and there was a question about who was the aggressor and who was the victim. And it's brought to the officer's attention there and then, when there's the disputing story between the two people, there's video recording in here, and it's readily available.
Well, if someone had said to them, "There's a video recording of what happened tonight and it's readily available," maybe that would be the case you're describing. All this person said is there's recording equipment here.
Yes, and I think what he says in his affidavit is that he had expected them to take the camera as evidence or to look at it. And I do take the court's point that there is not evidence in the record that ZJ had said, "Please view the recordings before deciding whether to make an arrest." And I think, I'd love for that fact to be in the record, and it is, and it's not there.
I do want to talk about what is in the record from that night, though, and take you back to that pages 17 and 18 of the record appendix, which is Officer Callahan's report. She reports, "Upon my arrival, I could hear a female screaming coming from inside an apartment. I approached the door and saw a male tightly grasping a female's arm, walking her toward the door. The female was visibly upset and crying. The door opened and I ordered the male to let go of the female's arm. Then she talks to the wife, who tells Officer Callahan some things. Officer Callahan also observes injuries on the wife's body, a bruise on her right arm, and 2 small scratches. Is that not probable cause to arrest your client? Putting aside the question of who started it this time, putting aside the question of who starts it most times, putting aside the question of who was winning, is that probable cause to arrest your client?
In the abstract, Your Honor, but I think when we look at the record, it's very hard to read into this record anything like a finding by the trial court judge that any of that was true. All the trial court judge said with respect to the factual information in the record is he said to the appellant's attorney, "I accept everything you're saying." And part of what the appellant's attorney was saying at the trial court was, "You should credit my client's affidavit."
So what if I disagree with you that that was what the judge found? Because to follow your argument, I would have to then agree or believe, conclude, who knows what the verb is, that the judge credited the affidavit of your client over the contemporaneous or roughly contemporaneous report made by the arresting officer.
I just don't know how else to read the record except that if there was fact-finding below, and there needed to be fact-finding to dispose of this motion, that was the fact-finding. And if there is any moment for pause by the court with respect to whether or not that was fact-finding or what it means, I would ask for a remand so that the judge can clarify. When I said I accept everything, did I mean I accept the affidavit? What about the contrary information in the police report? If the police report had been found to be accurate, I don't think I could make out either of the 2 legal arguments I have. They're both pure legal arguments that hinge on the trial court having found, as a matter of fact, that he was accepting as true the content of the affidavit. I've got about 3.5 minutes left, and I know, Justice Rubin, you did express some potential skepticism around the fraud on the court argument. I'd like to give voice to it, if I may, for just a moment, unless there's other questions on the demonstrable error prong. And basically, there's 2 cases I want to emphasize here. One is the Adams case, 65 Mass App Court 725, which precedes the enactment of the expungement statute, but there had been a history of inflicting violence and threats of violence, and it was a single fraudulent procurement of a 209A order that used the court system as an instrumentality of that pattern of harassment to such an extent as constituted fraud on the court.
And in Adams, there were 19 separate false statements under oath and 4 different affidavits submitted to the court. And there was an application for the 209A order, and there were lies to the Board of Bar Overseers. Do you agree with me that those additional facts are not present here?
That's correct. Those are additional parts of the pattern of harassment, but I do think that if I'm correct that the trial court found, as a matter of fact, that ZJ's affidavit was accurate, ZJ's affidavit does make out a pattern of harassment. And the reason I bring out Adams is because Adams, and the other case I wanted to cite to here was Moe, 463 Mass 370, where again it was a single usage of the court as an instrumentality of the fraud.
So every single time there's an altercation between two people, and the first aggressor says the other person started it, you can't arrest the other person, and if you do, everything gets expunged because the first aggressor was lying.
Certainly not, Justice Rubin. First, there must be a pattern of harassment as made out in ZJ's affidavit, which, again, my arguments do hinge on that.
Pattern of harassment isn't fraud on the court. The fraud is the filing of the complaint or whatever, right?
Or the making of the statements to the police.
Yeah.
The procurement of the 209A order. In Moe, it was a false report to the police that the defendant had threatened the alleged victim with a gun, and so that's a false report like we have here, and that ended up falling apart after the defendant in Moe tried to extort the alleged victim, and that was held to be a sufficient pattern of harassment with one fraudulent usage of the court as part of, as an instrumentality of that pattern of harassment that then constituted a fraud on the court.
Do you think your stronger argument is the fraud one or the demonstrable error one?
I think they stand something close to equipoise. It would depend on which day and what time of day I think, evaluating them. But I do think they're both meritorious arguments, and I guess the last thing I'll say is on that demonstrable error one, it's an underdeveloped area of case law. I think there's 3 unpublished cases. Each of them hinge on an officer's credibility determinations rather than the officer failing to review objective evidence. So where the officers knew that there was likely video recording going on at the scene of the crime, I think if it were an altercation at a gas station and there were conflicting stories about who was the aggressor and who was the victim, it would be demonstrable error for the police to make
Every self-defense case has this characteristic you're describing.
Except it doesn't have the video.
And neither do you. You don't have a video.
I mean, I guess we have a video certainly of prior instances, as Justice Rubin's pointed out, and I'd urge the court to please watch the videos in conjunction with making your decision.
So I don't think we have them.
Oh, I had submitted them on a disc to the court via the clerk's office. I submitted 2 discs.
All right. If we have them, we'll... Sure, of course.
You have a waiver argument, is that right?
That's correct.
Okay, so with respect to that argument, you agree that the Commonwealth was not present for the argument?
No, it's unclear from the record whether or not the Commonwealth was there. I agree that the Commonwealth did not put forth any opposition in the trial court.
Okay, and do you know whether typically in this sort of a motion, the Commonwealth would have a say? Are they a party that naturally comes to these kinds of, this motion to expunge or seal? Is that something where the Commonwealth is sort of the other party? I
don't know. What I would say is that when the Commonwealth wants to make these arguments on appeal, it's incumbent for the Commonwealth to preserve them in the trial court. And I submitted a 16L yesterday with Maurizio, where the Commonwealth was held to have waived an argument in favor of affirmance, and the court declined the Commonwealth's invitation to, affirm on a ground supported by the appeal, although supported by the record, although not raised below.
Though in Maurizio, that was an argument that the Commonwealth failed to make at a trial at which they were present and participating. So just to follow up on Justice Singh's questions, do we have, obviously I could look at the trial court docket, do you know from the trial court docket whether the Commonwealth was notified that this motion had been filed, that the hearing had been set?
I would have to look at the petition and the certificate of service thereon Certainly, the Commonwealth has not raised any argument that there was a failure of notice. And with leave of court, I will look at that and submit a post-argument letter if the court would like.
It's up to him.
It's fine. It's fine, yes.
Unless there's any other questions, I'll rest on the briefs.
All right, excellent argument. Thank you very much. Very helpful to us. We will hear next from Attorney McLaughlin.
Good morning, Your Honors. May it please the Court, Laura McLaughlin for the Commonwealth. The defendant is not entitled to the expungement of his criminal records where they were created as the result of probable cause, proper police investigation, and prosecutorial discretion. Further, as correctly found by the motion judge, the defendant's claims do not meet the narrowly tailored statute or statutory standard for expungement.
Do you agree with Attorney Rusille that the court's statement on page 5 about accepting, even if I accept everything that you're saying, which I do, is a factual determination by the judge that in favor of the defendant's affidavit?
Absolutely not, Your Honor. The Commonwealth's reading of that transcript is what the motion judge says is that he accepts everything that the defense attorney is arguing. What the defense attorney is arguing is that there exist prior videos showing the victim, as in this incident, as a primary aggressor in other incidences. Those videos were intended to be offered by the defendant, produced to the Commonwealth over a year into the prosecution as part of his affirmative defense that he was not the primary aggressor. At that motion hearing, what the attorney is arguing is that there is the existence of these videos, and that the motion judge says, I understand what you're saying, but it does not meet the narrowly defined statutory reasons for expungement, and then the motion judge offers, I will seal the record. I understand what you're saying. There's no reference of crediting the defendant's self-serving statements within his affidavit. What the Commonwealth would like to further articulate, what Your Honors have been aware of, is that there is no video of this incident. There's absolutely no reference that a video was taken, that there's any recordings known to exist or have ever been produced in this case. What the evidence shows in the police report is that the individuals fought over the placing of cameras. There's no indication that the cameras were operable and recording this incident. Further, the defendant did not introduce any videos of this incident. Further, the statements in reference about the defendant's cell phone recording the police interaction that was noted by officers at booking, the defendant was instructed to stop recording officers and to turn his phone off. What the defendant is essentially requesting is an unreasonable burden on law enforcement, but also a incredibly large infringement on a suspect's reasonable expectation of privacy in their phone. As this court and the SJC has determined, an individual, particularly a suspect in a criminal case, has significant privacy interest in their phones.
Well, but he could always assume for the moment that what your brother argues is correct and that the images, the videos on the phone would actually have been exculpatory. There's certainly no reason Officer Callahan couldn't have said to the defendant, hey, do you mind if I take a look at the videos on your phone?
Yes, but he would have to know that the videos of the prior incident were on the phone.
I'm sorry, that was a bad question by me. I'm talking about the video of this particular incident.
He could have always asked for consent to say, can I search through your phone? But there is no indication that the defendant ever made any statements of, I acted in self-defense, or I did not do anything. Look at the video on my phone showing what happened 25 minutes prior. That is not what occurred. What is the responsibility of law enforcement is to make judgment calls based on the evidence and probable cause before them at the scene of the crime, which they did do, and they did properly investigate. Looking at the argument about the fraud on the court, the Commonwealth would argue that there is absolutely no evidence of a pattern of harassment or fraud perpetrated on the court. Citing the case Adams that the defendant relies on, the court defines fraud on the court implies corrupt conduct and embraces only that species of fraud which does or attempt to defile the court itself. Here, there is no evidence that the victim ever made any false statements to law enforcement or any misleading of the court or misuse of the court.
Why isn't your argument waived?
So the information that I have is that the Commonwealth did receive notice of the filing. I believe it went to the Quincy District Court office. From the transcript hearing, it's unclear if the Commonwealth was present in the courtroom at the time the hearing proceeded, but it does appear that the Commonwealth as an entity received notice of this motion. The Commonwealth's argument is not waived because to accept that, that would mean the Commonwealth would have no ability to respond to the appeal, that I would not be standing before you putting forth any arguments of law.
That's what it would mean.
Yes.
It would mean you better go into court when you get notice that there's a hearing so that you can preserve your appellate rights.
Well,
if a defendant doesn't raise some issue, then they have no appellate rights.
Well, this court, as your honors are aware, can affirm on other grounds, but however, the Commonwealth isn't
I
arguing.
think it's other grounds that were raised below. I'll have to look. I feel like I've seen it written different ways.
What the Commonwealth is arguing, they're not putting forth any alternative arguments. Essentially, the Commonwealth is just arguing that the court correctly found that the defendant's claims do not meet the narrowly tailored statutory exemptions for expungement. That is what the motion judge ruled, and that is what the evidence put forth to the court would show. And unless your honors have any other questions, I would rest my brief and respectfully ask that you affirm the motion judge's order denying the expungement.
More questions? Further questions? Very good. Thank
you.
you very much. Very good arguments by both of you. Very helpful to us. The case is submitted. The next case is number 22-653, Commonwealth versus CZERKAWSKI. We will hear first, wait till everybody's ready. We will hear first from Attorney McKenna.
Good morning. May it please the court, and thank you for hearing this case before the break. James McKenna for Mr. CZERKAWSKI. It's a rare case, very rare case, as this court well knows, that on appeal we can establish there was an abuse of discretion below. But it's a very rare case where a trial-level judge determines that the behavior of the Commonwealth was totally inappropriate and really prejudicial. It's an extremely rare case where between the time of the crime and the time of the trial, a memorial is built in the town where this happened to the victim. It's even rarer when the legislature passes a statute increasing the penalty for the conduct based upon the case, which is exactly what happened here. This case, as this court well knows, tests the limits of our jury system. We're asking 12 peers of Mr. CZERKAWSKI to sit and calmly, through tears perhaps, and rationally decide whether this is the guy who committed these horrible acts. There's no question what happened here was horrible.
You get trials of crimes with horrible acts every day.
You do, Your Honor, and they land in this court all the time. But the jurors, in this case, didn't have that happen.
Well, let me ask you this. It looks to me like about 32% of the veneer had heard of the case.
Yes, Your Honor.
Okay, so 68% had not. It seems to me that at the end, 4 of the 12 deliberating jurors had heard of the case. I read the voir dires of each one of them,
Thank you, Your Honor.
where the judge found them to be nonetheless fair and impartial. And that seems, I mean, some of them had heard, just heard of it, or, you know what I mean? They didn't know much about it or whatever. Why isn't that adequate under our case law to assure that your client had a fair trial?
Under Skilling, the federal law, they speak about how it has to be an extreme case. Under Tulin, which adopted Skilling, they echo that. They have the two-part analysis. And with respect to the first part, the presumptive prejudice, Your Honor is absolutely right. Number 36, number 38, number 42, and number 63 heard about this and sat. Numbers 32 and 37 heard about this and concluded my client was guilty before hearing any evidence at all.
You didn't use a peremptory to strike them.
They used peremptories on number...
You had leftover peremptories.
And the Commonwealth makes a strong argument in that regard. In terms of practicality, if you have juror number 78 who was seated and who spoke about how I can be impartial, but this goes to the heart, we use a peremptory on him. And if you have no peremptory at the end, and suddenly there is in the jury someone you really don't want there, it's bad. You shouldn't really finish. It would make sense, Your Honor, I would suggest, to not have no peremptories left, to have some left, just in case someone worse than 78 were to be presented in the jury pool. And in terms of an answer to your question, Your Honor, when Judge Fishman evaluated what the Commonwealth had done and said this is totally inappropriate, really prejudicial, and we'll leave it to the voir dire, the number, and I would thank Your Honor for going through and identifying the 32% number in terms of the proportion, which I think House speaks about that, the Hoose case, Hoose, how if there's a substantial enough number of proportion of the jury that's heard about this, then there is no presumptive prejudice. But if there is a sufficient number of the jury pool who's heard of this, then there is presumptive prejudice.
So are you arguing under both presumptive and actual prejudice?
Yes, and I would argue presumptive first, because that may be our stronger argument. Because to Your Honor's point, they were able to sit a jury relative to actual prejudice.
But so you would agree that there has never yet been a case in the Commonwealth in which presumptive prejudice has been found?
That's correct, Your Honor. The House case reversed based on the failure to do sufficient voir dire, but that was actual prejudice, not presumptive. There's also never been a case in which we have the facts like this. Presumptive prejudice in other contexts references what we'll call something of passing, totally inappropriate behavior, approximating that. In Skilling, the Enron case, the federal one, in House, in Tulin, in every one of those cases, they evaluated presumptive prejudice and decided whether or not to allow, on that basis, as Your Honor points out, they didn't allow. But in none of those cases was there inappropriate behavior by the prosecution.
But I don't, I've read, I can't say I've read every single one of the cases, but I've read the cases, and the determination of whether or not there is presumptive prejudice doesn't turn on whether it's the fault of the prosecuting body that there is so much news out there. It turns on how much news there is out there and basically how saturated the media market is. And if you look at some of the cases that have been tried in the Commonwealth in the last 20 years, not necessarily state cases, but the Tsarnaev case, the Bulger case, those cases were tried here in the Commonwealth despite pervasive pretrial publicity. And as you say, it's the federal law that has crept into the state standards here, so I don't think it's inappropriate to think about publicity in the context of both state and federal cases. How is this case, how was the publicity in this case more pervasive and more prejudicial than the publicity in those cases, or the Greiniger case, to go back, years?
In the Skilling, in the Tulin, and the House cases, there was no reference to misconduct by the prosecution because there was none. Here, we had the prosecution engaging with the angry mob, making them angrier. And on, I believe, Record Appendix 121, there's a Facebook reference comment by someone about how if you don't want to riot, you better bring this person to trial. And rather than ignoring the troll or whoever this is, or this angry person, rather than ignoring them, the district attorney engages and makes a
But
comment.
there's no evidence that anyone in the jury saw these Facebook posts.
They saw, the jury pool was exposed to Facebook. A number of jurors referenced having seen Facebook coverage of this. And in a way, it's almost like a copyright matter, where you have a copyright violation by those who are exposed to the material and produce something substantially similar. In a way, it's like that. But here, certainly you had the question before the jury. The only real question was, did Mr. CZERKAWSKI do this? Did he do this? And you had, and this really...
But that's always the question before a jury.
It is.
And the way that we have devised of figuring out whether a particular juror is the appropriate person to answer that question is through questioning designed to determine whether the person can be fair and impartial. The judge asks questions, the attorneys either directly or through the judge ask follow-up questions, they're peremptory and cause challenges, and then people are seated. So turning to actual prejudice, you've mentioned that two of the jurors who were seated, who were not, on whom no one used a peremptory, although peremptories are available, said that they had heard of it. But there's any number of cases saying that just being aware of charges or aware of a crime that has been charged doesn't mean that a juror can't be fair and impartial. So what is your best argument that the jurors who were seated in this case were either actually not fair and impartial, or that their seating was the result of a process that did not appropriately tailor itself to finding fair and impartial jurors?
Probably the best argument is that there were some jurors, number 32, number 37, who heard the same type evidence, pre-trial publicity, which was fostered by the prosecution, and concluded that my client was guilty, based simply on that. 32 spoke about how he had priors, and that was part of what was released by the prosecution. And they have on, I can find the record appendix page number for that, 119, the prosecution references he's being held on other charges. They made the mob angrier. For what it's worth, the delays have been at his request. That's on page 111. This is the government getting the angry mob angrier. And one thing that angered Judge, if I may, Your Honor, one thing that angered Judge Fishman, apparently, and this is reading through a transcript, is on page 103 and 106 of, it was referenced by 103 and 106 of the transcript. The Commonwealth makes a good point in its brief.
Transcript day 2 or day 1?
I'm sorry, the record appendix, Your Honor, not the transcript. 103 and 106 of the record appendix. The Commonwealth makes a good point about the distinction between statements made before an arrest and after the arrest. And the idea being that after the arrest there'd be less inflammatory statements made. There is an argument that there's no need to inspire people to work for the prosecution who are already at a vigil for the dog. But in terms of Judge Fishman's reaction, what he called totally inappropriate and really prejudicial, they left that on the website. And
But you're not making a prosecutorial misconduct argument, right? I mean, that's not, your argument goes right again to the jury selection process.
Yes, Your Honor. You're absolutely right, Your Honor. And that goes to the presumptive prejudice part, which, based on the Tulin test, Skillings, and House, does not include a prosecutorial misconduct element. There's one here in terms of the inappropriate behavior.
Well, again, let me take you. So it seems like a lot of your argument rests on a conclusion by a judge that this conduct that the prosecution engaged in was actually inappropriate.
Yes, Your Honor.
All right. We're not necessarily reviewing that judgment call, right?
Right. And if you were the Wood case.
Would we have to review that judgment call to entertain your argument?
No, Your Honor. I don't believe you would. the Wood case would be helpful in that regard. 2014, where the DA's office in Suffolk released a press release during deliberations. Every word based upon the case seemed to be factual. And the SJC said, you can't do this. That's one press release. That's not having the pre-arrest statements remain on the Facebook page.
There were protesters at the actual trial, is that right, that had to be kept away from the sidewalks or away from right around the courthouse, something like that?
Yes, Your Honor, they had a buffer zone, and they wouldn't have had a buffer zone if this was in Hampshire County or in Hampden County or someplace not in Quincy.
And was the motion to change venue, when was that made? Was it made right at trial or earlier?
It was made twice. Once it was discussed in July 2017, and again in October 2017, denied by Judge Connors in July, denied by Judge Fishman in October, with Judge Fishman saying, let's see how voir dire goes. And we had jurors come in crying about, literally crying, about what they had read in the paper. We had...
So there's the agreement, it sounds like, was let's see how it goes, and then it went. And nobody raised it again as being an issue, right?
That's correct, Your Honor.
Wait, you said it was made twice, the change. When was the second time?
The second time was with Judge Fishman in October 2017.
And when was trial?
It was 2018.
So the issue of there's protesters around the courthouse was not part of the motion seeking a change of venue. It was publicity in the community and so on, but not, and now there's a bunch of protesters outside.
I believe that's correct, Your Honor. I believe there was a buffer zone put together. Earlier in July 2017, they discussed matters such as that and motions in limine.
The creation of the buffer zone was a year before trial.
I believe so, Your Honor, but my
Okay.
belief is not based upon clear recollection.
That was Judge Fishman's, part of Judge Fishman's order created the buffer zone, I believe.
Okay, thank you, Your Honor. With respect to identity, what remained on the website were things like the police chief saying the investigation took a long time because we wanted to make sure we got it right. They're saying this is the guy. They're telling the jury pool, we've got him.
But I think, again, you know, one could just follow Judge Fishman's lead and say that was all inappropriate and shouldn't have happened. And it should not have been up for as long as it was up, and it had to be taken down. But the question that's before us is not that. The question that's before us is, could a fair and impartial jury be impaneled through the process that was used here?
With respect to actual prejudice, absolutely yes, Your Honor. And if I could just finish one thing I started before, then interrupted myself a few times on that. 103 is a press release from October 2013, October 8, 2013, by the DA's office before the arrest. Still on the website, and in June 2017, it's in a local publication. The quotes from the district attorney are then, in 2017, back out again.
Was there, just one more question for you, were there any motions to strike for cause any of the 4 jurors who sat who had heard of it?
No, Your Honor.
Okay. All right, excellent, interesting argument.
Thank you very much.
We will hear now from Attorney Cusick.
Good morning, Your Honors. May it please the Court. My name is Tracy Cusick. I'm here on behalf of the Commonwealth. Your Honors, this case was tried by a fair and impartial jury, and I suggest the Court can find that by looking at the extensive procedures used to select a jury. With respect to the question about the buffer zone, this defendant's first trial in Norfolk County was in 2015, and Judge Fishman presided at that trial for larceny, and a buffer zone order was entered in that trial. That buffer zone order was then brought into this cruelty case, and Judge Connors said he was going to issue that buffer zone order Judge Fishman said he was going to issue that buffer zone order, and then ultimately Judge Cannoni issued that buffer zone order. And the record does show that there were people coming to the courthouse. I suggest that those persons were holding signs, and there's ample evidence in the record as to what was going on. And the buffer zone order was designed to make sure that a jury did not encounter any of those persons or see any of what they might have on their signs regarding the defendant or their opinions.
And there was no motion by the defense that that had been, that somehow jurors had been exposed to them?
There was not, Your Honor. In the record, there is some discussion. At one point, Judge Cannoni, the ultimate trial judge, said that in light of the absence of any sort of disturbances or concerns, that she was thinking of bringing the buffer zone, making it smaller, and both parties asked her not to do that. Again, the thought being, if this gets out, people might take that as permission to create some sort of a demonstration 100 yards away or 100 feet away from where jurors might be. And the defense attorneys commented at some point that they had been monitoring online activity, they had seen a lot of chatter on social media, but again, there was no evidence whatsoever that any member of the jury or anybody involved in the case was participating in any of that. In this case, first, several things caused the trial to be continued that were not related to concerns about pretrial publicity. It was continued from the July trial date, and the eve of trial, a prosecutor had a medical issue. It was continued to October when Judge Fishman was to preside. The defendant had a medical issue, and then it was continued to March of 2018 when Judge Cannoni did actually try the case. And the motion for a change of venue was not presented to Judge Cannoni to rule on. Instead, the defense attorney said, I'm not asking you to revisit my venue motion, but I'd ask you to take Judge Fishman's approach of seeing how it goes and what happens in terms of whether a jury could be impaneled. This was one of the earlier cases where the attorney-conducted panel voir dire process was used in Norfolk County, and in this case, panel voir dire was used. On the first day, the jurors that were selected were seated in the box. Panel voir dire, attorney-conducted panel voir dire was conducted, and then peremptories were exercised. On the second day, the process was repeated, and at the end of the second day, when 16 people had been seated, 3 people remained, and the defense still had 2 peremptory challenges. So certainly the defense could see if he used any of those challenges on anybody who had been seated, who was coming next, and the defense attorney elected not to use those peremptory challenges. To ensure the fairness here, the judge gave each party 8 peremptory challenges as opposed to the usual 6, and the judge sat a 16-person jury as opposed to the usual 14 in this type of a case. And
how many peremptories did the defense have left at the end of this?
2 peremptories were left for the defense. I believe the Commonwealth also had 2 left. And the judge also used a written questionnaire for jurors, and I suggest everybody was examined extensively at sidebar, and the court has those transcripts to see what was asked of people and how they responded. Many people had expressed opinions that they were passionate about animals or that they were very upset about the nature of the charges that were before them. And I suggest some folks also mentioned publicity. Some of them mentioned publicity. Clearly they were aware of this defendant. I believe 2 people were actually right on point as to what this was. Other people seemed to had seen something in the media somewhere about animal cruelty and may have been conflating it with this case. But I suggest here, in light of the extensive procedures that were used to seat this jury and the absence of any objection by the defense to anyone who was seated or to the procedures used or to anything else, shows that a fair and impartial jury was seated. If there were no further questions, I would rest on my brief.
All right, thank you very much. Very good arguments from each of you. Thank you. Unfortunate case, interesting issues. It is submitted. Keep going. Keep going? Sure. All righty. The next matter we will hear is number 23-284, Fournier versus Polar Corp and another. It's my understanding that the appellees will be dividing their time, 7.5 minutes each. Is that correct? Sure. Very good. We will hear then now from Attorney Mangini.
Thank you, Your Honor. Good afternoon. As it may please the Court, Attorney Laura Mangini for the Plaintiff Appellant Lilian Fournier. We are here today requesting that this Court reverse the judgment dismissing Plaintiff Appellant's claim at the summary judgment stage and remand this matter to the Superior Court for trial. The reason for the Plaintiff's Appellant's brief is that the trial court erred in finding that, as a matter of law, the defendant appellee, Megan Scahill, was in fact impaired by a sudden medical emergency, and that that sudden medical emergency caused the collision. The evidence presented at the summary judgment hearing and in the record lend to different plausible interpretations which should be reconciled by a trier of fact and not by a summary judgment trial court. Now, at the outset, one of the things I want to note is although appellees argue that there's no case placing the burden of proving a sudden medical emergency on the defendants, I would suggest that this is actually inaccurate. And in Carroll versus Booley, the Supreme Judicial Court stated in no uncertain terms that the real issue upon which the defendant had the burden of proof is whether the evidence required the jury to find that Boulay was not a responsible operator at the time of entering the intersection. So I would suggest to the Court that under that case, it is the defendant's burden to prove that they did have a sudden medical emergency and that that medical emergency caused the collision.
Does that alone mean there can't be summary judgment?
No, Your Honor, and I would suggest that there are a number of cases in which summary judgment was in fact found in favor of the defendants, but there is a difference in those cases. In those cases where summary judgment was actually found, the defendant in that case went to the hospital and sought medical treatment, and there was an actual diagnosis in all of those cases. In this case, as I'm sure the Court is aware, Ms. Scahill went to the ER after the accident, but she left against medical advice approximately 15 minutes later without receiving any testing. So there's no actual diagnosis as to what caused the syncope episode, if she even had a syncope episode. Now, I know my brothers argue that on the ER records, there's a clinical impression of syncope. And I would suggest to the Court that a clinical impression is simply a preliminary diagnosis, and there's no reliability to that diagnosis. And in that regards, I'd point the Court to Commonwealth versus Waite, 442 Mass. 792, 1996. And in that case, the Court specifically stated, a preliminary diagnosis is not a definitive diagnosis that can be relied upon, as it is not developed far enough for an indicia of reliability. And again, in that case, the defense expert relied on a preliminary diagnosis, and the Court said that that was not an appropriate piece of evidence for the expert to rely on, and so they disregarded the expert's opinion.
Well, I mean, I want to be clear about what Waite does and doesn't do for you. In Waite, the SJC determined that it was not an abuse of discretion for the judge to have excluded the evidence because it was preliminary. But Waite doesn't say that it would have been an abuse of discretion to admit the evidence. So I don't think it bears quite as much pressure as you are trying to put on it.
I would agree with that, Your Honor, and I would suggest that that fact that it's just a preliminary diagnosis and it does not actually establish what the causation is that caused that syncope episode is the real issue in this case. If you look at that ER record, specifically Record Appendix Volume 1, page 208, there is a note on there that the patient was advised to assess for the cause of syncope. So at this point, there is nothing that establishes what caused the syncope and whether or not it was a sudden medical emergency that therefore caused the accident.
So sorry, just to follow up on that, there's never going to be that evidence. Ms. Scahill didn't stay at the hospital.
Correct.
She was not examined at that moment.
Correct.
We're never going to know what that examination would have shown.
Correct.
So whether the decision stays or we do something else, including remanding for trial, the evidence at trial presumably is going to be the two drivers who saw her operating the vehicle and testify as to what they saw, the one of them who approached the car afterward and will testify he had to bang on the window and she still didn't come to, the treating EMTs from the scene, and the hospital records such as they are, and the testimony of Dr. Barrick, which even though you argued in your brief that it's not reliable, it's part of the agreed statement of facts, so I'm not quite sure what we're supposed to do with that dichotomy. But I guess what would be helpful to me is for you to to articulate, given that the evidence is constrained as it is, and given that I think a fair interpretation of what you've put forward on your client's behalf is argument, but not countervailing evidence, how does that advance your cause in terms of, that you're asking us to decide that the judge got this wrong?
Sure, thank you, Your Honor. And I do agree that all of that evidence that you suggested would come in at a trial, and a jury would be able to hear that. But there's additional evidence that's contained in the record, including at the summary judgment hearing. In terms of Ms. Cahill herself, she testified at her deposition that she told the hospital that there was no injury to her. She also testified that it was literally just a period of time that she cannot account for. She has no idea what caused the collision. She doesn't know if she had a medical event that caused her to lose control of her vehicle. That's page 96 and 97 of volume 1 of the appendix. And she also admitted, which I think is important, that she had a prior addiction issue, which is also in the record, that it was in 2016. So just a year before this accident, she had a prior addiction issue. And I think that prior addiction...
A prior addiction issue?
Correct, drug addiction.
Oh.
So where she
also testified to complete that thought, though, that because of that prior addiction, or I think probably ongoing addiction for which she was in recovery, she had not used for a year.
She did testify that, but a jury could disregard that testimony as evidence. And I think when you look at the totality of the circumstances, the fact that she does have admittedly a prior addiction issue as 1 year before in 2016, combined with the fact that she then leaves the ER against medical advice before any testing can be done to determine what, if any, impairment she had. There was no blood testing done, no urinalysis that would show whether or not there was actual drugs in her system. And then on top of that, when she's requested to go to her work to give a drug test because she was in the course and scope of her employment at that time, she also refuses to to go to work and give that drug test. Now, I also understand that, just to complete her deposition testimony, that she does suggest that there was other reasons that she didn't do that. But again, that's for a jury to decide. And at this stage, if there's a reasonable inference that a jury could make that perhaps she was impaired for some other reason than a sudden medical emergency, that is a question for the trier of fact that should go to the jury, and the trial court should not be making that determination at summary judgment.
So I have two questions about that, because I think this refusal to take a drug test seems significant. And I don't understand the judge crediting reasons that she gives, right? That's sort of what the trier of fact is supposed to do. The counsel on the other side says that you have conceded that she didn't take any drugs for 6 months prior to this. And they point to something that is called statement of agreed upon facts, although I notice it's only signed by their side. It's not signed by your side. What's the, I mean, of course you're arguing that she may have taken drugs. I assume that's a major theory of yours for what may have caused this accident. So what do we do with that? And is that something you agreed to or conceded? I don't quite understand.
In terms of the statement of facts, that is what the defendant testified to in her deposition, that...
Yeah, but you don't have to agree to that. That's her deposition.
Correct. Correct. But that, at that time, that's one piece of evidence that they have, that there's no way for the plaintiff to dispute that what she says, because there are no drug tests that she took.
You think that's all the statement of agreed upon facts says, is that she says?
She says the plaintiff did not take drugs, or I think it's drugs or alcohol within this, or prescription drugs within, I think she said, the 6 months prior, and then it cites to the plaintiff's, the defendant's deposition testimony or answers to interrogatories. From a summary judgment standpoint, there was no evidence that the plaintiff could actually cite to support that, because there are no prior medical records, there is no prior drug testing.
I'm not asking you that. I'm asking if you conceded the point.
We do not concede that point.
But it says in the agreed upon statement of facts is an agreed upon statement of facts.
Correct.
Even though it's not signed by you, it's signed by them, it's agreed upon. And I don't know, I mean, I didn't understand why you would ever agree upon this. I assumed your theory all along had something to do with drugs.
And I would suggest, Your Honor, that I noticed in one of my brother's arguments that they responded that the plaintiff did not submit their own statement of facts. Those are actually contained in the summary judgment opposition, which under the new, I think, Superior Court, I'm not sure which rule it is, but it's not a separate statement of facts that's submitted. So in our statement of facts, We do point out the fact that she did not submit to a drug test for work and that she did not undergo additional testing at the ER. So those facts are in the summary judgment record. And so those facts, and again, even if she did not take drugs for the 6 months before the accident, that doesn't prove that she wasn't impaired on the day of the accident, that she hadn't ingested something on the day of the accident.
Well, I mean, on page 28 of volume 1 of the record appendix, and this is in the party's consolidated statement of facts, number 12 is, Scahill did not consume any alcoholic beverages, medications, and/or prescriptive, I think that's supposed to be prescription, or non-prescriptive drugs within the 24-hour period prior to the subject accident. And the response is admitted. Why is that not binding for purposes of the summary judgment record? I'm not talking about a trial record, but for the purposes of summary judgment record, that was admitted.
I think, Your Honor, that in combination with all of the other evidence that is also in the summary judgment record, there's still a reasonable inference that can be made that a jury could find.
But I'm not talking about a jury. I'm talking about the record that was in front of the judge on which the determination that we are now reviewing was made. Isn't the judge entitled, doesn't the judge have to take as admitted things that are admitted in the consolidated statement of facts?
I would step back a minute and say, even if that is admitted, and even if that the judge has to rely on that, there's other potential inferences that a jury could also make, putting aside the drug issue and the impairment issue for a moment, that with this evidence, again, one of the witnesses initially testified that he thought Ms. Scahill was on her cell phone when he drove by her. So that is something that a jury, that inference at the summary judgment stage should be drawn in favor of the plaintiff. It's a non-moving party, and it should go to a jury. There was other testimony, and I believe it was referenced in both the summary judgment hearing and I believe in the criminal transcript, which is also part of the hearing, that one of the witnesses initially thought she was asleep. And so, again, there's, putting aside the drug issue and the impairment issue, there's other issues that can be, that a jury could find as a reasonable inference.
And you think there's sufficient evidence in the record that a jury could find by a preponderance of the evidence that she was asleep or on her phone?
Well, I think it goes back to the larger problem that there really is no evidence in this type of case because the plaintiff did not, the defendant did not seek medical treatment, and so there's nothing.
That is evidence. That's evidence that she didn't just have a sudden medical emergency. I think a jury can draw an inference against her. Why isn't she getting medical treatment if it's a sudden medical emergency? I mean, it's nice that she says she doesn't have insurance, but whatever. They don't have to believe that, and they don't have to believe that's why she walked away. Maybe she walked away because she knew, I don't know what, they weren't going to find that she fainted. If, I don't know if you can find that, but she might have thought they could. You know what I mean?
And I think, again, because there's other, the jury could disregard that at the summary judgment stage. If there are plausible alternatives, no matter how unlikely it is for a jury to find it, if there are other plausible alternatives, those inferences have to be drawn in favor of the non-moving party, and it should go to a trier of fact. So where there are these different potential options, again, whether she was asleep, whether she was on a cell phone, whether she's just saying, I don't know what happened, I'm not going to take accountability for this because I caused this huge accident. We don't know because she literally does not recall any part of what happened after she pulled out of the Walmart parking lot.
She testifies that she doesn't recall.
Correct.
She may be lying.
Correct.
All of her testimony may be false, right? So, all right.
And so all you're left with, if you look at the two independent witnesses, all you're left with is that her head is down and she's bobbing, her head is bobbing. One thinks she might have been on her cell phone. And then when he goes to wake her up after the accident, she's unconscious. But again, that does not establish that she was unconscious during the entire time that she was driving from the right out of Walmart until the time of the accident. That would potentially only establish that, there's other reasons that could have caused that. I also just want to point out, in my limited time that I have left, I just wanted to touch base on the issue preclusion issue that my brothers raised in their brief. I would suggest that in the criminal trial, there was specific evidence that did not come in, that would come in at the civil trial. Again, no evidence of a prior drug history was brought in, no evidence that she may have been asleep at the wheel, no evidence that she left the hospital against medical advice. And there was also another fact that she refused to speak to the police department 2 days later when they requested she come in for a statement. All of that was subject to motion in limines, which did not come in at the criminal trial, which would come in at the underlying civil trial, presumably. And if there's no further questions from the court, I would rest on my brief.
Thank you very much. Interesting case. Excellent argument. We will hear first from, among the appellees, we'll hear first from Attorney Wygand.
Yes, good morning. I believe this case presents a straightforward application of fundamental principles of summary judgment, as well as the rule which is not disputed, and that is evidence of an unforeseen medical emergency which renders an operator unable to control a vehicle negates the essential element of breach of duty for negligence. And the court recognized that principle, and there was evidence provided by the defendant to negate the fundamental element. It included an expert report that this episode was a syncope episode that was unforeseeable.
That expert report is not of any value. That person didn't even examine the person. So what is it based on? There's no medical record to look at? What is this doctor looking at exactly?
He's looking at the circumstances surrounding the incident, the eyewitness reports, the medical records to the extent they did exist, the information.
Why do I need a doctor to look at eyewitness reports?
Well, he's looking at the circumstances describing what was learned about the incident, that this person was seen unconscious by two different eyewitnesses, that she had no history, she was evaluated at the scene by a drug expert who found no evidence of impairment.
Okay, but that's not really a full diagnosis. She didn't have a urinalysis or blood test.
Well, he had breath test. He also did.
Yes, but drugs don't show up on a breath test. Alcohol does.
That's true, Your Honor, but there was no actions or statements that indicated in any way she was under the influence of anything.
She drove across a bunch of lanes and into a car in a parking lot, killing someone. That might be evidence of impairment.
The mere fact of that action, I don't believe.
No, not by itself.
Right. The plaintiff had a burden here to come forward with affirmative evidence to create a non-speculative basis of negligence.
Why isn't refusal to get a drug test affirmative evidence that has to go to jury? I'm not saying what happened. I have no idea, obviously, what actually happened. But I'm just saying the question is, I think the question before us is, did the judge resolve some factual disputes here that shouldn't have been resolved by the judge, but that are for the fact finder? I think that's the whole question.
He didn't improperly resolve any factual record. He was given a factual record, as noted earlier, of what the agreed statements of facts were. He took those facts as accepted, which is what you're supposed to do at summary judgment, and he applied the law to those facts. And as to your question about her refusing to have a medical exam, the record reflects that we don't know when that was requested. It certainly wasn't on the day. It was in the days or weeks afterwards.
Okay, but we see this all the time when there are train accidents, plane accidents, right? In some cases it's mandatory by law. In some cases it might be in a collective bargaining agreement, right? So I don't know what the rules are, but someone goes and gets a test. And some tests, of course, hair tests, for example, go back a long time.
Well, look, there's no dispute that she declined. She gave the reasons why. But for you to decide that this judge erred and that there is non-speculative evidence for a jury to conclude that she didn't have a sudden medical emergency, despite Dr. Barrick's opinion, despite the eyewitnesses, despite being evaluated at the scene by a drug expert, her own statements of not having memory, no skid marks. The reconstruction report also said that when it travels in a straight line, like she was observed for the last 1,000 feet, that indicates that the operator has no control.
You should tell a jury, shouldn't you?
No, the plaintiff had to come forward with affirmative evidence from which a reasonable fact finder could find that that's all not true and she had some kind of unknown impairment.
But I think this is what you're saying, I just want to make sure that I'm right. Are you saying that on these agreed facts, no reasonable jury could find that anything other than an unforeseen medical emergency caused the accident.
Non-speculative, correct.
So for the evidence that we know on the summary judgment record, that would be speculation.
Correct. And in taking the issue of whether she fell asleep, the plaintiff offers, oh, she might have fallen asleep. Well, we know that the evidence that she got a good night's sleep the night before.
She said, of course she's going to say things, everything she's going to say is going to be exculpatory, just like anyone who kills someone in an accident.
That means that if you prevent a record, there's nothing to suggest
the jury should hear her and see if she's credible. That's why we have juries.
Well, to go through the issues of the evidence, there's nothing to rebut that wasn't true, that she showed up at work at 7 o'clock, worked from 7 to 8 stacking the soda in the Walmart, and then shortly after getting into her car has this episode. It's not a situation where she was driving all day or at night on a long highway where you might infer that falling asleep is a possibility. This is a far speculation to say she fell asleep.
Seems like speculation to say that she fainted.
Not when you had a doctor look at it, not when you had the facts as eyewitnesses saw that she was unconscious, and the fact that we don't know the exact cause for her syncope, many times that's the case. We never find a cause for why someone suffers a syncope episode. But they had an obligation to come forward with a medical evidence to suggest something more than speculation, and they didn't meet their burden, and that's why we have summary judgment.
So
and I submit
in your view, someone in Ms. Scahill's position who has just caused an accident, a serious accident, and then refuses medical attention, in other words, someone who chooses not to create evidence, then benefits from that lack of evidence by saying to the other side, prove it. Get the medical evidence that would exist if I had agreed to be treated, but does not and will never exist.
Well, I understand. I think that's a fair observation, but it's not exactly this case. We take the whole evidence or the record, the summary judgment record that was before the judge, and that's just one piece. She was seen and observed by the nurse, and there was an initial clinical impression of syncope. Yes, we don't have the blood test, but we don't have anything else.
Or a diagnosis. We have a clinical impression.
Well, we have, right. It's
based on her self-reporting.
And Judge, I'm not going to sit here and tell you that controls. It's just a piece of the puzzle. And it's a piece of the evidence that was not properly refuted to create a reasonable issue for a jury. It would be based on speculation to say she fell asleep, based on speculation to say she was impaired.
So even if there could be a negative inference from from leaving the hospital or not taking an exam, that negative inference, you're saying, doesn't create affirmative evidence of some alternative cause.
I think the way you said it is well stated.
Well, wait, that can't be right. All day long, we take people's children away from them because they refuse to take a drug test. All day long. We treat their refusal to take a drug test as affirmative evidence that they're using drugs. So it can't be that it's not affirmative evidence. It may not be enough, or it might be speculative, or you know what I mean, but it can't be that it's not.
There wasn't enough here to create a non-speculative basis to say she didn't have the syncope episode or that she was able to control the car. You certainly didn't hear, there's nothing here, despite the plaintiff's argument, that she was on notice that she was susceptible to some medical condition that would cause this. There's no evidence whatsoever, and two of the decisions of this court have upheld summary judgment where there is the lack of such evidence.
All right, your time has expired, and unless there are further questions, we will hear now from Attorney Stewart.
Yes, Your Honor. Your Honor, my brother and I, our arguments are very similar. It is our position on behalf of Polar Corporation that Ms. Cahill was overcome by an unforeseen syncope, and the thing about syncope is it's not the kind of thing that you can do a blood test after and say, oh, you had it. The only thing that you can really do is look at the history and the symptoms and what the evidence in the record was that Dr. Barris had the benefit of hearing from these witnesses.
But a blood test could show if you didn't have it.
I'm sorry, Your Honor?
A blood test could show that you didn't have syncope, because it could show a high level of opioids in your system or something else, right?
I think that notion was put to rest with Officer Cody, the certified drug recognition expert, that saw her immediately after the accident, and she was kind of in a haze, and from the trauma of the accident and being unconscious, but he was able to, this is his job, to see if a person is under the influence of any sort of drugs, and he came to an opinion that she was not. So,
But he came to that opinion, among other things, by using the nystagmus test, which I thought we did away with in the late 90s. So there's room there at trial for cross-examination. I think, one of the challenges for me here is each side here is basically saying, listen, these are the facts, and, one of you is saying it can only go one way, and the other is saying it could go either way. And if there's any possibility of it going either way, don't you lose? I mean, isn't that a judgment call, determining facts, that by definition means summary judgment is inappropriate because there might be another rational view?
Your Honor, I'm looking at this another way. I'm looking at the Curvicillus paradigm, okay? And I'm looking at the party moving for summary judgment has an initial burden to demonstrate by certain admissible materials that evidence is unlikely to be forthcoming that could support a verdict for the plaintiff.
Well, it's not just unlikely, right? It has to be that no rational view of the evidence would support.
I'll get there, Your Honor. What I'm saying is we met our initial burden to demonstrate that there was no negligence because of this syncope, the unforeseen medical emergency. At that point, the burden shifts to the defendant to prove this happened because of negligence. There's always a burden of proof on the plaintiff to prove negligence. And in this type of situation, it's sometimes looked at as an unavoidable accident. I mean, if you go through the ALR annotations, different states look at it different ways, but I think Massachusetts says an unforeseeable medical event that happens that the operator of a motor vehicle or a boat didn't know what was going to happen, with fear immediacy. It can't be something remote. In that situation, there's no negligence. So what I'm saying is we met our initial burden to shift the burden to the plaintiff. And at that point, the plaintiff didn't come forth with evidence of an accident that was the fault of the operator. If she wasn't conscious, she wasn't negligent. Your Honor, there are cases...
Well, but, I mean, I agree with you that if she wasn't conscious due to no fault of her own and due to an unforeseeable medical emergency, that she wasn't liable. I think where your sister takes issue with that is the conclusion, what you would like to put forward as the conclusion that this was an unforeseeable syncope episode is not, she would say, supported or is not the only rational conclusion one could draw from the agreed upon facts.
I think it is, Your Honor. I think to get to another place, I'm suggesting a conclusion. To go to another conclusion, I think you're going to have to use speculation or surmise or conjecture.
But why isn't it speculation or surmise or conjecture to get to the syncope conclusion? There's no diagnosis. There's no post-accident examination. There's no post-accident drug testing. There are observations of two eyewitnesses that are arguably, I'm not saying I believe it, but arguably as consistent with having fallen asleep at the wheel as they are with having become unconscious.
Your Honor, syncope is always diagnosed after the fact based on the history that the person that is now awake gives. In this case, we had much more than the average syncope diagnosis. I grant you, at the hospital, all we had is a clinical impression of a nurse, okay? But what Dr. Barris, the expert, was able to look at that was enough, I say, to demonstrate that negligence wasn't going on here and shifts the burden to the plaintiff. What we had, Dr. Barris relied on much more and fully sufficient, and he was able to say, based on good medical certainty, that it was syncope. So I think we're also looking at, well, we want to give, the standard is that the plaintiff gets the benefit of reasonable inferences. I'm saying that to go there, we're talking about speculation. I'm also saying that we can't just look at what the driver said and disbelieve her and come to an opposite conclusion. That isn't a way that we, that isn't evidence of the opposite proposition, the fact that we don't believe her. So I think we need to credit the evidence that we're saying was sufficient to shift the burden. The bottom line is the plaintiff never came forth with any evidence that Ms. Cahill was conscious, that she was in control of her vehicle when this happened.
She doesn't have to have been either conscious or in control of her vehicle.
We can't disprove it. You can't prove a negative. All we have to do is demonstrate by reference to Rule 56E materials that that evidence is unlikely to be forthcoming at trial. That shifts the burden. We say that the burden was never met. This is a case where negligence was not proven. There are plenty of cases where there's a rear-end accident, and if that's all we have, if we have a mere accident, that's not proof of negligence. You need to prove something else was going on, that the driver departed from the standard of care to be reasonably careful, and that's very similar to what we have here.
Is there
Yes, Your
a
Honor.
statement is there any expert statement that the circumstances are inconsistent with someone falling asleep or inconsistent with someone being under the influence of drugs?
Your Honor, if somebody falls asleep without any warning, that would be a case where there would be no negligence. However, if the person hadn't slept the night before or was terribly upset about, I can think of circumstances where falling asleep, there would be negligence. It would be foreseeable. I will mention that Ms. Cahill testified, and again, this is what we talked about before, that she had a normal night the night before, didn't have any trouble sleeping, went to bed at the usual time, got up at the usual time, had a regular breakfast. We ruled out a whole bunch of stuff that could have been useful here. I say in the summary judgment paradigm, we can't just say, well, we don't believe her, so she must have not have had enough sleep. It doesn't work that way. What we're saying is that evidence of disbelief is not proof of the contrary proposition, and I think that applies here.
All right, your time has expired, although if there's anything else, I don't see any further questions. Thank you, all three of you. Excellent arguments. Interesting case. It is submitted.
Thank you, Your Honor.
This brings us to the final case of the, well, no longer morning, of the day. It is number 23-136. This is DEROSA versus LENOX Farms Limited Partner. And we will hear first from Attorney Bruno.
Thank you, Your Honor, members of the panel. If may it please the court, my name is Melissa Bruno. I represent the appellant, THERESA DEROSA, in this matter, who's also the tenant in this matter. We are here asserting that the lower court erred in granting summary judgment in its subsequent denial of our motion for reconsideration with regards to the presentation of expert affidavits subsequently to the motion for summary judgment, and that this was an abuse of discretion. The lower court's findings were based on the determination that DEROSA's treating allergy specialist, as well as the report of the mold testing that was done, was not sufficient to survive a motion for summary judgment, and this error undermined the fairness of the proceedings to a sufficiently serious degree that relief should be granted.
Can I ask you about that mold, I'll use the word expert loosely, not in a legal sense, was not part of the summary judgment record. I see it at Record Appendix Volume 3, page 131, which seems to be part of the motion to reconsider. I did not find it, but I'm not very good at finding things, in the attached to the parties' joint statement of facts for 9A. Was it part of the 9A record or not?
I do not recall off the top of my head if it was part of the 9A record, but there was a report from the person who tested it, and they submitted it to a lab called ProLab, and that was part of the summary judgment arguments, and was a very controlled issue within it, saying that they were not considered experts within that field because it wasn't based on scientific sufficiency within the field of mold testing.
So the judge, I just want to make sure I'm understanding, the judge had, you think for summary judgment, the judge had the mold report, but not necessarily the affidavit?
He did not have the affidavit. He did not have the affidavit until the motion for reconsideration was filed.
Okay.
Did the defendant move to strike the mold report?
There was no move to strike the mold report that I can recall.
Doesn't all of this get resolved due to the discovery issue?
So with regards to the mold report, as well as the Dr. Young, who is the treating physician, who's an allergy and specialist, and was her treating physician, all of those records were disclosed during discovery. They actually were done through Keeper of the Records, through my sister counsel, and were certified
as experts.
They were not certified as experts. They did not sign an affidavit, and the 30B disclosures were not done. We were given a deadline at a status conference for the disclosures to be made. We never had a pretrial conference where we did a pretrial conference memo or anything along those lines. And so when it came to the summary judgment motion, I requested on the record that I'd be able to provide those affidavits, because it's not a surprise on my opposing, on my sister counsel, that these individuals are the ones that we will be utilizing at the time of trial. There's nobody new. These are the same people that we've been dealing with since even before litigation started in this matter. So that's why I asked for an accommodation to be able to provide those affidavits after the fact.
Doesn't the rule require that you provide the affidavits much sooner than that? And isn't a possible remedy for violating the rule that the testimony is then excluded?
So we were unable to obtain the affidavits prior to the fact based on where the individuals were. Dr. Young was on vacation at the time, and Dave Jensen was unreachable.
For how long was the doctor on vacation?
It was shortly before once I got the motion for summary judgment and I began compiling my opposition, that's when I reached out to them to try and obtain an affidavit.
And what was the deadline for expert disclosures?
I believe it was December 15th of 2022.
And when were the summary judgment papers?
The summary judgment papers were filed on December 22nd, 2021. Lennox served its motion for summary judgment. On January 12th, 2022, we served our opposition. And the entire 9A package was served on January 25th, 2022.
So would you agree that the expert disclosure process was not followed here?
I would agree, but I think it could have been cured in order to continue on to trial. But secondarily to that as well, I'm not, part of our argument is that it wasn't necessary to have experts in this case in the first place. The treating physician could have provided evidence and could have provided their records to show a causal relationship between the injuries that she suffered and what he had specifically treated her for. And he did that by reviewing the report of the mold specialist, which Dr. Young actually asked her to produce and get in the first place. He said, get a mold expert out there immediately to have your air tested.
I have a question about one of your factual assertions. Your client maintains that she made the lease contingent on the unit being free of mold and harmful particulates. I understand that that's her response to interrogatory questions, that she's testified to that at a deposition. Is there any contemporaneous written evidence that the lease, that her agreeing to the lease was contingent on that representation? I looked through the lease, I didn't see anything, no amendment, no markup. Are there emails pre-signing of the lease where she says it's contingent on this?
There are definitely emails going back and forth with regards to her proclivity to mold and mildew and dust mites and those kinds of things, and that the unit needs to be free of those in order to her to move in. She went to the unit and viewed it 2 times, and she was especially concerned because of the carpeting within the unit.
And I know there's the whole back and forth about whether the carpet is hypoallergenic, but I'm asking a more specific legal question, which is you're making a claim that it was a condition of her signing the lease that it was represented to her that the apartment was hypoallergenic. Is that the fact of that condition committed to writing anywhere?
In emails between the parties.
Okay. It would be helpful to have the record appendix citation for those particular emails.
I can look those up and submit a letter later so that way
That'd
you can
be
have
great.
it. Yeah.
Thank you. Can I ask you a question? You argue at one point that the negligence claim is not mold-based. What is the negligence if it's not allowing mold in the apartment?
So her claim is twofold. She really believed when she first moved into that unit that the reason why she was having all of these issues was because it was an unhypoallergenic carpet.
Okay.
They had assured her it was hypoallergenic. There is an email that later says, actually, based on talking to the manufacturer, it is not hypoallergenic, and then it was removed subsequently to that about 5 months later. So during that course of 5 months, she suffered a great deal of emotional and physical distress based on the fact that she believed that it was the carpet that was causing all of these.
So this is negligence and her harm is emotional or physical?
It's both.
Is there any evidence that when the carpet was removed, her physical symptoms reduced at all?
No.
So how would you prove that the carpeting, I see you refer to it at one point as something that could trap the mold inside the apartment, which I don't know, I'm willing to believe. But if it doesn't get any better when the carpeting is removed, what is her injury? And can there be a negligence claim where emotional injury alone is sufficient?
So after the carpeting was removed, they removed it from especially the upstairs bedroom, the main bedroom where she was, where they had these French doors that would open up. Mm-hmm. And once the carpeting was removed, she noticed after a heavy downpour that rain came flooding into the apartment at that point in that room. And so she called and reported it immediately. And that's when she began to realize, wait a second, if this is happening now, this has been happening the entire time. So it's most likely that this floor has been flooding in the subflooring. It now has mold and mildew underneath it. And so she had requested that some sort of dampness testing or something be completed along those lines to assess the situation. I would say that Dr. Young, despite, even if we argumentatively say that he is not an expert based on the submissions, that he did provide a causal link between the mold in the townhouse as well as DEROSA's ongoing ailments, and this is conveyed in his medical records, which have been certified via 23379G appropriately and pursuant to Bailey v. Cataldo Ambulance Services. A medical practitioner who has treated the patient before the commencement of a lawsuit, independent of any referral by an attorney, will generally be more credible than a retained expert witness, and that's the case here with Dr. Young. The case that my sister counsel points to a lot, the Avalon case, had a twofold kind of doctors that were taken out of the game, as if you will, during the course of the summary judgment. One of them was a treatment provider, and the other one was a doctor that was hired as a medical expert by the attorney at the time. And I would argue that the fact that Dr. Young was her medical practitioner, he had a better ability to causally relate all of these injuries to her than some medical expert that's just reviewing some medical records and being paid to appear at a trial and go through a whole records review, and that he was prepared and ready to do so as well. I think that if we had had a pretrial conference memo, that probably would have helped as well, if we had been able to list him as maybe not an expert witness, but as a fact witness under those circumstances, but that wasn't the case here. Also, the court erred in determining that DEROSA's treating asthma and allergy specialist, Dr. Young, was not qualified to opine on the presence of airborne mold, and his assertions were speculative. The judge determined that he should have essentially gone out into the home and done his own testing to determine whether or not there was any airborne mold or anything along those lines. And we strongly disagree with that assertion, and that doctors don't normally go out to their patients' residents to see what their living environments are like, and that shouldn't be a necessary prerequisite in order to decide if a physician is sufficiently credible to testify at trial with regards to his fact-finding abilities and looking at his client.
Wasn't the judge simply saying that he's not qualified? He may be qualified to talk about the medical condition of his patient, but not of the presence of the mold, right? To that extent, because he's got no expertise in that. You would agree?
Right, and so he had reviewed the report from the environmental tester, the mold spotters, before he wrote a subsequent letter in December stating that it was the type of mold that was found in there was very specific to the type of mold. She's not your everyday plaintiff. She's not your everyday tenant. She's not what's covered necessarily under the sanitary code. She is way more susceptible to this type of mold and mildew, and it made her life unlivable. She had to leave the apartment, otherwise she was not going to get better. They had exhausted every means of medication. She had gone to doctors over and over and over again, different kinds of doctors, different emergency urgent care facilities to try and figure out how to get this corrected, and nothing was helpful. So the only alternative she had was to leave. And when she had left the premises previously, she would notice that all of her symptoms would go away. She went to France for a short time to visit her daughter who had just had a child, and all of her symptoms were gone, only to return the moment that she came back to the unit. So she spent a lot of time there and spent a lot of time trying to work with them to get it fixed. And it just, at the end of the day, it was unfortunate, but it didn't work out. And she wanted to live there. She spent a lot of money to live there. But her son also, who's impaired, lived there with her as well. So it's not like they moved out because, she was just, I'm upset because my eyes hurt. She physically could not live there anymore. And if I have no other questions, then.
I see none. Thank you very much. Excellent argument. And we will hear now from Attorney, I'll pronounce it wrong, Dodar. But I'll give it a go.
Good afternoon, Your Honors. May it please the Court, Gayatri Devthar for Lennox Farms Limited Partnership. This case turns, in essence, on the lack of evidence, and particularly the lack of expert evidence, that the plaintiff had in her case, particularly in the summary judgment record, which I think is the primary record that should be considered here. And that lack of evidence informs her inability to prove any of her claims in this case.
Okay, this is a weird case to me, because I read the summary judgment record, and here's the impression it left me with. There's obviously a genuine issue of fact about whether mold caused this woman's suffering in the apartment. And then the judge does this sort of weird, instead of saying like, well, there's a mold report that you didn't move to strike, and there's a doctor's letter that you didn't move to strike, and I read these together, and this certainly raises a genuine issue of material fact, he starts talking about identifying possible expert witnesses as the basis of this. Are there other cases in which the failure, even though there's evidence in the record from which, not struck on the grounds that it's inadmissible or anything else, where the mere failure to list expert witnesses is the basis for summary judgment? Do you have a case like that?
I think that the Avalon Bay case is similar to that. I think the case that Avalon Bay cites, which is Avalon Oaks versus King, is also similar to the situation that you're presenting here. I don't believe in that case an expert was disclosed, and the court came to the same conclusion as the court in Avalon Bay, that you have to have someone who can make a causal connection between a condition that the plaintiff is claiming, in this case, exists in her unit, and the symptoms that she is suffering. It is not enough
But the mold report is in the summary judgment record, and you don't object to that. That's admissible evidence. Is that right?
Well, I don't think, if this case had gone to trial, I think a motion to strike would have been appropriate in that case.
Well, if you didn't want it in the summary judgment record, a motion to strike would have been appropriate there.
And I think that what's important about the mold spotter's record and what is significant about that record is a few things. One, it talks about only normal levels of mold in that unit. It doesn't, it is absolutely silent.
Elevated mold conditions is what it says.
And it's silent as to whether those elevated mold conditions are actually dangerous, if they are
Okay,
toxic.
that's not, they don't know that. That's not their question, right? They're just testing for mold. And they
Right.
didn't find normal levels of mold. They found elevated levels of mold. Then we have a doctor writing in a letter that, among other things, says that there are high levels of mold. The judge says, for some reason, that's speculation. I don't know why that's speculation. He has a report from a mold place that says elevated levels of mold. And frankly, he's an allergist. I have no idea because we haven't gone through the process of figuring out what allergists rely on in the ordinary course of whether they can look at hearsay reports or, how they figure out what's what. Maybe he actually knows independently, wow, 1,100, that's high. I don't know the answer to that. He's an allergist. He may know that as a part of his training, or he's relying on the report of this mold place, and maybe doctors rely on that. So I see this judge trying to thread this needle of, you didn't disclose an expert, and I don't know who these mold people are. Well, I don't know. You can look at the report. It looks like it's done by a mold testing company. You know what I mean? Now, I'm not saying they're a good one or a bad one, and maybe you could move to strike that at some point. Maybe there isn't. But to say it's not evidence at this stage doesn't seem right to me.
I think that what has to be considered is that there's 2 points in time in this case in which Dr. Young is opining that mold is causing the plaintiff's symptoms. There's the point in time where she's actually living in the unit. And what's important is that she gets the mold spotter's report after she moves out of the unit. So for the pendency of her time in that unit, she does not observe mold in the unit. She makes no complaints about mold in the unit.
I mean, I don't know whether her lease still existed or didn't. My sense is that your client didn't let her out of her lease. So I don't know. The day of the testing is literally the day after she moves out.
Yes.
Whether the fact that her stuff is moved out makes any difference, I don't really know. but, and I don't know everything about mold, but I think if you test the day after you lived there, a reasonable inference is it was like that the night before as well, right?
But I think that what's important is that in the absence of that report, the plaintiff doesn't have anything to show that there is mold in her unit that is causing her symptoms. And so
Well,
the doctor,
I mean, I don't know completely about that. We know she has a mold allergy and she's having the symptoms of the mold allergy, and I don't know if that, how good evidence that is or whatever. But it is in the record, the mold report. You're saying in the absence of it, and maybe, but it's in it.
it is, but I would submit that the lower court correctly found that the mold report, first of all, we did not stipulate to the admissibility or the reliability of that mold
You
report.
didn't move to
Absent
strike
that,
it,
we
it's
didn't
in the
strike it.
report,
Yes.
it's in the place. You didn't say this, you didn't say, and I don't remember what the rule is, doesn't it have to only lead to discoverable evidence? I don't, right, so.
Yeah, I will concede that we did not file a motion to strike, Your Honor, in this case. But I think that what's important is that all we have in the absence of any other information from the plaintiff, and counsel has conceded that this affidavit from Mr. Jensen, who's the one who actually did the testing, all of his qualifications, anything that he did that qualifies him to come to these conclusions, that was never provided to the defendant at the summary judgment stage. It was only provided after the fact, when it was too late to admit that into evidence from our perspective. And so all you have at the end of the day is the plaintiff's assertions first that there is mold in her unit, and she's telling this to Dr. Young.
Mold
and
report
he's
from a
making
company
his-
that says, I believe the
Yes.
company is called something like mold specialists or.
Mold spotters, yeah.
Mold
Yes.
spotters, okay. Now, maybe they don't know anything about mold, but
Yeah.
this is summary judgment, right? This isn't the whole trial. It's certainly a reasonable inference that they know something about mold.
But I think that what's also important is on the first page of that report, the Mold Spotters report specifically states that there are no federal regulations in place governing what constitutes a dangerous level of mold.
But you have an eggshell plaintiff here.
Yes.
And there is, at least in the record as it was presented to the judge at the summary judgment phase, there is at least a legitimate question, if not a conclusive determination, that your client was aware when she rented that she was an eggshell plaintiff. Now, it may not matter that they were aware. I don't remember that that's a critical point of the law. Frankly, I went to law school a really long time ago, and who's thought about the eggshell plaintiff since then? But it may be that it was a completely normal level of mold. If it's a level of mold that causes this particular person to have serious health problems, I don't think it saves your client that it's a normal level of mold. I think what you have in the summary judgment record, and I will confess that I was frustrated by both sides' briefing in this case, that it wasn't, the factual citations weren't limited to the 9A record, which they really should have been. That's what the judge is looking at, and therefore that's what we need to look at. We don't get to start over. So the 9A record has the treating physician saying, look, this is my patient, she has a serious mold problem. It has a report that may not be self-interpreting, and that is certainly not interpreted on the 9A record, but that does say an unusual level of mold was found. Why isn't that enough to get the case over the summary judgment hurdle and in front of a jury?
Because I think that there is precedence in the case of, and I'm citing again to Avalon Bay.
No, but that's not, that case doesn't, we don't have to follow that case. It's not the SJC, it's not even the appeals court.
I understand, but I think what I would suggest to you is that even if Dr. Young were permitted to testify at trial as a fact expert, which is what the plaintiff is saying he could have done, I'm not aware of a treating provider who is testifying as a fact expert being able to testify as to the causal connection between the medical symptoms that his patient is appearing with and the treatment that he is providing and what is actually causing those symptoms. So even...
Well, but I mean, think about what you just said. Let's say I'm in a car accident, I'm now knocking on wood, and I am taken to MGH, and I come in and the ER doctor is told, we've just gotten this person out of a car with the jaws of life, and, I've got, let's say, like my sternum is broken and, some other thing, like internal organ damage. Can't that treating physician come to trial and say, maybe not it was caused by a car accident, but I saw these injuries. I work at an ER. We get a ton of people who've been in car accidents. It was reported to me that this person came out of a car with the jaws of life, and the injuries I saw are consistent with the injuries from a car accident. Doesn't that happen like 7 days a week?
It does, but I think this is a slightly...
Doesn't really, because there's only 5 days a week that you're in court, but please continue.
I think that this is slightly different, and I understand what the Mold Spotters report says, and I understand that it talks about the elevated levels of mold, but I think that there is a difference between a very obvious accident that results in injuries as opposed to airborne mold, which becomes the plaintiff's argument, that there's airborne mold that is causing me symptoms, that is causing me to have respiratory illness.
Well, that's a diagnosis question. Mesothelioma is caused by exposure to asbestos. Doctors come in and say that all the time.
But I think in that situation, you would have to first be able to have Dr. Young show that he, in the first instance, had an independent basis to believe that there's mold, apart from what the plaintiff is telling him.
Yeah, the mold report.
And then when he gets the mold report, you would have to show, I think, at trial that the mold report itself is admissible and reliable.
No, actually, if he's testifying as an expert, he can rely on inadmissible evidence if in the profession, the ordinary people rely on it. But I think the critical point is at trial. Mm-hmm. At trial, you can try to knock the underpinnings all the way out of all this stuff. But it's in the summary judgment record. And drawing every reasonable inference from it, I don't know. I mean, like I say, when I read the record, I thought, oh, maybe mold is causing, in the apartment, is causing this stuff. All the evidence, you know, going away, coming back, all that.
The only other thing I would say is that a lot of things can cause respiratory illness, apart from mold. Allergens can cause respiratory illness.
Well, mold is an allergen in this case.
Well, yes, allergens apart from mold is what I meant to say. And so there is the plaintiff who has the burden of proof has not submitted any evidence to show that any outside allergens other than mold can be excluded as the cause of her plaintiff's.
Is she required to rule that out? I mean, for example, in my unfortunate hypothetical, would I then be required to rule out if the treating physician says, oh yeah, she was in a car crash? I don't have to rule out that I fell off a carnival ride or that I stumbled going down the stairs. I mean, I have a doctor saying this is what caused the injury. Why isn't it the same for the plaintiff here?
Again, I would say that the mold report talks about elevated levels. I understand that the court considers her to be an eggshell plaintiff, but again, there is nothing to show that the mold report was reliable. The plaintiff, Mr. Jensen's affidavit came after the fact, so we don't know what his at that point, we did not know what his qualifications were to come to these conclusions.
But the report was part of the 9A record.
It was part of the 9A record, but...
You're saying it's basically not self-authenticating or not self-explanatory, or what's the...
I'm saying that the results of what are in that mold report were not qualified by an expert. They were just submitted as is. And so we don't know, that the defendant does not know what testing was done, how the testing was done, who did the testing, if they have experience in testing. We don't know any of those things.
But again, you didn't move to strike it on that ground.
We did not.
So it's in the summary judgment record.
Yes. Just if I could address just a couple of other points. With regard to the plaintiff claiming that the lower court was wrong in lumping her negligence claim in with her mold-based claims, I understand she's talking about her client suffering emotional distress damages, but I think that that is a bit of putting the cart before the horse. I think before we can talk about damages, you have to establish duty, breach, and causation. And our position is that absent any evidence, expert evidence, factual evidence, the plaintiff has not established negligence. And so we can't talk about emotional distress damages because there's nothing before that. She's sort of jumped straight to the
Wait, I don't understand why you need... I think she's saying the negligence with respect to the carpet is you told her it was hypoallergenic, then you found out it wasn't. Why do we need an expert?
I think what the record actually states, and I believe it's Record Appendix 2, page 204, 201, that there's an email from the community director at the time, and what he actually said to her is that the carpet is not marketed as hypoallergenic, but it is hypoallergenic by definition, and this
All right, so
is
that sounds like,
why.
and I think she's saying that was negligent, because it's not hypoallergenic.
But I think that's also a moot point, because the carpet, she conceded, plaintiff's counsel conceded in her opposition to the motion for summary judgment that the carpet was never the issue. So I think that's
Can
a bit
you,
of a
can,
red
I don't
herring.
remember what the law is in Massachusetts. Can you have emotional distress in a negligence case without physical injury, or only where there's also physical injury?
My understanding is that there has to be some physical injury to show emotional distress.
We'll look, or I'll, you know, or if no one else cares, I'll look.
That's right.
All right, your time has expired. No further questions. Thank you for excellent arguments, both of you. Another really interesting case. It is submitted. And that brings us to the end of our sitting for today. I would like to thank the court staff for their assistance. I would like to thank the court officer for his excellent assistance as always. And we stand in recess. I know. That's me, or problem.
The recording was off, right?
I don't know what that is.